Tom Hruz, for those wondering, the H is silent. I've been serving on District 3 Court of Appeals. It'll be 10 years as of this September, which is hard to believe. I was appointed in 2014 and have run for election in 2016 and 2022. District 3 Court of Appeals is the northernmost part of the state, 35 of the 72 counties, very large geographically, but smallest by population of the 4 Court of Appeals districts. And our district has 3 judges total, the fewest of any of the districts. Today, with 2 other judges, Judge Tammy Johak and Yadra Reen, we talked about advice based upon our life experiences, work experiences for young lawyers and what they can glean, both as do's and don'ts, tips for feeling better about how they practice their career, how they interact with other attorneys and with the court, and for those who might be interested in serving as a judge someday themselves, some ideas that might enable them to do that. Yeah, for us, I mean, I say every case we have begins with the standard of review, and a lot of them end, frankly, with the standard of review. That is to say, we have to, when we're looking for whether there's reversible error, we have our toolbox of issues that have with them the standard of review, which can go from de novo review, so questions of law. We have no deference to the lower court, and we decide what we think is correct under the law or the statutes without any deference, to, on the other end, erroneous exercise of discretion. And that's really important because attorneys need to recognize that even if they thought they should have won on a particular issue, or their client was really focused on a particular issue, if it has that kind of standard of review where all we have to do is see that the court reasonably exercises discretion, even if we would have done it differently, we're going to affirm. And unless you can meet that standard, it's best to find an appellate issue that you might have a better chance of winning given the record and our standard of review. So that's number one, is that. And then the second one, and they're related, the second one is, given our standards of review, oftentimes I'll see attorneys, what I'll characterize as retrying their case on appeal, as if we're the fact finder. And I'll even write that in the margin of briefs. I'll say, this is just retrying the case. And that doesn't typically get you anywhere. And it's funny you use that term. I call it the C's. You need to write concise, you need to write clearly, and you need to write compellingly. And those 3 go together and overlap for the most effective writers. And something we talked about at the seminar, or at the last session, is very important too, is we're a high volume court, and we read a lot of cases, we work on a lot of cases at any given moment. And we're not familiar with the case like you are, at least when we start off. And you have to speak to us in a way that makes clear what this case is about, what the record is, what the issues are, and why you think your client should prevail in whatever shape or form. And obviously you don't need to be too rudimentary, but at the same time, there's nothing wrong with being careful and citing, even if it's well-established law, repeating the law, just to be clear to us that you know what the law is. You probably know that we know what the law is, but there's no harm in restating it and then applying it and doing it in a way where, where we get to the end of the brief and if you've done it correctly, we're like, wow, this is really, really good stuff. Yeah, and for that, I'll have to preface it with, we have a unique style of doing oral arguments in D3, District 3. It is conversational. We don't have time limits. We don't have a strict, appellant, respondent kind of time period. We are very conversational, and the attorneys that do best are themselves conversational. And we like to think we ask very probing and difficult questions, and attorneys, there's nothing wrong with an attorney saying, and we just had an argument last week, as a matter of fact, in Superior, and at least I think both attorneys would do this at various points, where he or she would say, Well, that's a good question. Let me think about that for a second. Take a second. You don't have to. There's no demerit in your argument if you recognize, and frankly, you're showing at some level, you're showing respect to the court because you're saying that I can't answer this right off the top of my head because this is something I haven't thought of. And one of the attorneys said, I hadn't even thought about that, but let me think about that. And so be conversational and humble, at the same time, but show a command of the case. I mean, and that's the biggest thing going into oral argument. And when I used to do that as a practitioner, you should welcome questions. You should want to know what the judges are thinking about and listen to their questions very carefully and not say, I think I understand your question, but let me focus instead on this. No, I'd kind of like to answer a question. Right. This is an interesting trick, if you want to call it that I used, and it's true, is that, like I said, at this point, once you've gotten to an oral argument, you should have, you fully briefed your case. You might have lived it at the trial court level. Maybe you took it on just on appeal. But either way, you've read the record thoroughly. You've read the relevant case law. You've read your opponent's brief and your brief. You know the case. Find somebody to not do you can do a mock argument, and those work very well, but just find somebody, whether your spouse, your sibling, or if you want, another colleague at your firm, and just go into a room and talk about the case. Have them ask questions. How would you tell that person who's not familiar with the case what it's really all about and why you should win in, a couple minutes or less? And then digest that process and then figure out, okay, these are the essential parts, and that type of process, again, it can be with anybody. Sometimes we think that you're going to come in prepared, and but anytime you talk about something, and that's what an oral argument is. Like I said, it's a conversation. You should have conversed with other people about that case before. And again, sometimes the best conversations are with people that aren't lawyers, because that's the best way to communicate that you know what's going on in the case and that the person you're talking to is understanding you. Yeah, I mentioned this during the session. If you really want to do especially appellate work, and I'm focusing on that, and you have the capacity, there's a lot of pro bono opportunities out there, and you get real experience, and you get a chance to be for the most part a lead attorney on a case. And I know a lot of young lawyers who have done that, and because if you have a big end client, they're going to want the partner to make the oral argument. They're going to want some of them often have in-house counsel, so they'll have the final word on the briefs and stuff like that. But you get a chance to really engage in that, and so I would say that's a great opportunity as a young lawyer, is to find those pro bono appellate cases. The Seventh Circuit has a program. I think I think the Wisconsin Court of Appeal and Supreme Court have a program. So that's something I would recommend to get experience, because it can be very difficult. Like I said, a lot of run-of-the-mill clients like to have the more senior attorney being the face. So. A statement that you know this case very well, but just feed it to us a little bit more slowly. Don't come out of the gate, and even if it's an area of the law that we think we're familiar with, just lean into it. Don't come right out and just start citing cases and start talking about deep facts in the case without kind of laying that seed there and having a context that because again, it's very difficult to do, because you know this case left and right, and you have to kind of take that step back. And I think when I wish there was an appellate brief I wrote for an out-of-state appeal once, and the judge afterwards was like, "Boy, I really liked your brief, but I didn't really know where you were going until page 20, and then it really took off." And I'm like, "Oops." And I look back, and I did some my own personal Monday morning quarterbacking, and I said, "Okay, I see where she was coming from." So. Sure, and I was actually pleased that Judge Hawk had a similar experience. But sure, so my second day at the firm, I was just told, here's the case. We have a scheduling conference up in Washington County. You're gonna attend it on behalf of our client, which was a corporation. And I showed up in the courtroom and sat down at counsel's table, and the opposing attorney was there. I shook the hands and he said, "Well, you're new." And I was like, "Yeah, I just started." And the judge walked in, I forget who the judge was, and sat down, called the case, and said, "All right, appearances." And I didn't know what he was talking about. I said, "Well, everybody looks pretty good." Fortunately, the other attorney went first and said, Joe Smith on behalf of plaintiff, whatever. And then I was like, "Oh, okay, I got it." Tom Hruz, Meister attorney on behalf of XYZ, company. But it's something where, until you do it, you really just don't know what it was. And then it's funny because the rest of my career, that happens all the time, of course, but every time I would think about that first time and kind of snicker at myself. So.
Yeah. Well,
yeah, that was something that I don't know where it came from. I don't know if it even was conscious, and part of it was, I wanted to get it right, and I spent a lot of time reading the relevant rules or whatever, and but I wanted the partner, my mentor, to make sure that, reminder, this is the first time I'm doing this, so if I'm doing anything wrong or there's anything I could do wrong, if it was something like a deposition, this is the time to kind of help me out here. Because they're not keeping track. They might have thought, Tom's done a 30B6 deposition before, so he knows how to do it, when actually I hadn't, And so I think it was well received and it was a good process. And fortunately, after a year or two, those things became few and far in between. Yeah, and that actually that came out of a conversation mostly that the other two judges were having, but I was privy to it before the presentation. And Judge Ryan is new. Judge Hawk's been on the bench for a long time, and Judge Ryan said, I'm surprised at how many young attorneys, especially in criminal cases, show up for an appearance, and when we start talking about the case, they disclose that they haven't talked to each other, the two opposing counsel. And Judge Hawk said, "That's new. That wasn't the case, years ago when she first started on the bench." And she did attribute it to young lawyers. And, I'm not going to get into the social psychological phenomena that might be going on generationally speaking, but I do think it's important that, we do live in a culture, where people are texting and emailing, and they're texting each other when they're sitting right across from each other. And I think that does translate even into the legal community, where there's this aversion necessarily to interacting on that kind of communicative level that we're accustomed to, and frankly is beneficial. And they could speak, it's less relevant at the appellate level, but at the trial level, from my experience too, it is very important. I mean, if you go in, and frankly, I did this as a matter of course with opposing counsel, where, especially in certain counties, what their scheduling order is going to look like. So ahead of time, you say, how many days do you think you need for your experts? How many days? And you did this before you went in. The judges appreciated that, but it might be now that, there's just this reticence to doing that, and judges are like, "So you guys haven't talked at all about this case to each other?" Not a good thing. As I mentioned in the session, I found the state bar practice books, I call them the brown books with the exception of Arnie Anderson's insurance law. I really got to figure out that mystery, why that one's red covered and the rest are brown. But be that as it may, they're incredibly well organized in an outline form, and the index, so the table of contents and the index are very easy to navigate. And if let's say it's in a subject matter where you have very little experience, either from law school or from practice, you can really get a primer on that. And if you're writing a brief, they're updated, often. And as I mentioned, I actually write an appendix on standards of review for the appellate practice book. But Heffernan, the principal author for so many years, has put together just a very good resource and that was like my Bible when I was an appellate practitioner. I would always, of course I was just too focused on making sure I complied with every possible rule there, but especially if you're a trial attorney who doesn't do a lot of appeals, that book should be at your side when you are litigating an appeal. and it's incredibly helpful for you to comply with the rules, comply with everything in sequence properly, and it really is A to Z appellate practice, and that's true for the other ones, including discovery practice. That one I spent a lot of time digging into.